Thank you everyone for joining us today. This is a webinar on responding to administrative charges of discrimination and retaliation presented by Causal. We're very happy to have you here to discuss this topic, which I think is an important one right now. We've definitely been seeing a lot of administrative charges, particularly retaliation charges being filed. So hopefully this will give you some good recommendations, suggestions, and pointers on how to respond to those types of complaints. First, we'll take just a minute or two to introduce ourselves. My name is Lindsay DeSalvo, and I am a partner at Causal in both the firm's OSHA and employment practices. And a big part of my practice over the last couple of years, particularly, has been assisting clients with responding to administrative complaints, whether those complaints are filed with the EEOC, the Equal Employment Opportunity Commission, or with OSHA, retaliation complaints under Section 11C of the OSH Act. We have definitely been seeing a lot of them, particularly in the last couple of years. And so that has been a big part of my practice. And in conjunction with that, we also support our clients with developing workplace policies and procedures to ensure that there is a structure in place to respond to employee complaints, and that employees know that they have that ability to file these complaints internally and for the employer to address them internally, as opposed to going outside to these administrative agencies. I'll turn over to Megan to introduce herself.
Thanks, Lindsay. Good morning or good afternoon, everyone. I am also a member of Causal Carey's employment and OSHA practice. I am based out of our San Francisco, California office. So my work in this space tends to be through the California agencies, either through the California Department of Fair Employment and Housing, which has changed its name and is now Civil Rights Department, or through specifically the Labor Commissioner's office. They also handle retaliation complaints in a slightly different context, so although sometimes overlapping. So that's kind of where my work is in this space, and I'm excited to talk to you today, get into more detail.
So we want to cover basically four main topics today. The first will be just sort of an introduction into what these laws are. A lot of you will probably be familiar with the main laws that we're going to talk about and the major agencies that we're going to talk about, but we'll spend a little time reviewing that. And then we are going to spend some time looking at what the burdens of proof are. What are the things that the complainant needs to prove? What are the things, defenses that are available to employers to sort of set the stage for what you want to be thinking about and going into a response to the administrative complaint. Then Megan will talk about responding to administrative complaints, our suggestions related to the most effective ways to put together responses. And then finally, I'll close out by talking a little bit about some recommendations that we have to try to avoid these complaints in the first place, or at least to keep the complaints internal and managed by the employer as opposed to, with the agencies. So first, I'm going to cover in some detail the federal laws, the federal anti-discrimination and anti-retaliation laws that are at play when these types of complaints are filed. And that is predominantly going to be with the Equal Employment Opportunity Commission, or the EEOC. So the EEOC is the major federal administrative agency that handles complaints under the dominant anti-discrimination, anti-retaliation, anti-harassment laws. The greatest number of complaints are under Title VII, which protects employees against discrimination based on such protected categories as race, sex, and then several others, religion. And so that's where we see most of the complaints. That's where the allegations are coming from under Title VII and the protections that Title VII has. But the EEOC does enforce more than Title VII. It also enforces the Equal Pay Act, which we have seen an increase in the complaints filed under that law, the Americans with Disabilities Act, the Age Discrimination and Employment Act, and the Genetic Information Non-Discrimination Act. I'd say that we see probably the least amount of complaints filed under GINA, or the Genetic Information Non-Discrimination Act, but that is also a law that's enforced by the EEOC. So if an employer were to bring a complaint, that would be something that would also be brought before the EEOC. So because Title VII is the dominant law under which complaints or charges of discrimination or retaliation are brought, that's where we sort of wanted to focus as far as setting the stage for the laws at play here. And Title VII states that employers are prohibited from discriminating against employees for making charges, testifying, assisting, or participating in enforcement proceedings. And the anti-discrimination provision of Title VII is a major source of complaints that are filed by employees or former employees. But Title VII also has an anti-retaliation piece of it as well. And you'll see, we're going to spend a little bit of time just going through some statistics related to enforcement actions with the EEOC. And the anti-retaliation provision is definitely also a big source of, the basis for these complaints that are being filed by employees or former employees or potentially applicants. So we'll talk a little bit about the burdens related to the anti-retaliation piece as well. So here are some statistics. Every year, the EEOC does publish statistics on the amount of charges that are filed and sort of breaks them up by the basis for the charge, as well as several other categories that they split the data into. But what we're looking at here is the total charges that are filed and then them broken out by the basis under Title VII for which they were filed. So you'll see that a big portion of the discrimination claims are based on race. And that has been pretty consistent over, the last, it's about 15 years that this shows here, and the data goes back even further than this. But we wanted to focus on because of the fact, particularly, that we've been seeing a lot of retaliation complaints in the past couple of years. I mean, those are always sort of a big source of complaints. Or a big allegation in the complaints that are made with the EEOC. We see them quite often, even, if the focus of the complaint is race-based, there will also be a retaliation allegation made as part of the complaint. So that's what this shows here. And you'll see over the past 3 years, particularly fiscal year 2019, 2020, and 2021, retaliation claims have been made in about 50% and over 50% of the charges filed. And in fiscal year 2021, that number gets close to 60% of the charges filed. So retaliation is a big source of, the basis for these complaints. And that is why it will be important, in the slides going forward, we'll talk a little bit about what retaliation is and how it can be addressed in the response to the complaint, and then also strategies to avoid those types of claims. And then just a couple of statistics to show sort of how the enforcement process works. A majority of the complaints that are filed do result in a no cause finding, which means the EEOC investigates and doesn't find cause to proceed any further after their investigation. So basically, a no cause finding is almost the EEOC dismissing the complaint, but then the employee does have the ability to bring the complaint in court if they want to pursue it further. It is important, I think, to note that though the proportion of merit findings is substantially lower than the no cause findings, that number has been steadily increasing over the past 5 years. So it increased from 14.8% of the charges having merit finding in fiscal year 2017 to almost 20% of charges resulting in a merit finding. And a merit finding just means either, that the EEOC has found support for the complaints that the individual employee has made. And so, we'll pursue further enforcement action, potentially through litigation or settlement, in support of the employee's complaint. And in numbers, that means about 11,922 charges resulted in a merit finding in fiscal year 2021. And the last point here is just to sort of emphasize the importance of, why we want to be really considerate in how we develop responses to these types of complaints, is that in fiscal year 2021, total monetary benefits that were received by employees through the complaints they filed with the EEOC was about $350.7 million. So a significant number. Obviously, that will be much smaller on an individual employer basis, but still sort of an important thing to keep in mind in considering how strategic you should be in responding to these types of complaints. And I'll turn it over to Megan to talk a little bit about California.
Perfect. Thanks, Lindsay. So the relevant California provisions are stemming from the California Government Code, which essentially prohibits discrimination on the basis of protected categories. And similar to Title VII at the federal level, it can apply to not only employees, but applicants as well. And the complaints can essentially be stemming from those from that section, and it prohibits discrimination on the basis of various categories that are enumerated in the California statute. So in California, it covers a broad range, similar to at the federal level, race, color, ancestry, religion, age, which would be over 40, sex, sexual orientation, marital status, national origin, disability, gender identity, gender expression, medical condition, genetic information, and military or veteran status. And sometimes there's a slight discrepancy between what's protected at the state level and what's protected under federal law. And it applies across the board to most employers. There's different kind of subsections of the statutory framework. There's kind of the general anti-discrimination laws. There's a set of laws that are specific to California Family Rights Act, which is kind of a corollary to the federal, the FMLA, the Family Medical Leave Act. And then there's some specific provisions on reasonable accommodations for religious and disability. And so all of this is within the purview of the DFEH, which I'll probably keep calling them the DFEH for a while, but they have changed their name. They're now called the California Civil Rights Department. And they're the ones that enforce numerous laws, and many of these laws include anti-retaliation provisions. So when we talk about responding to a DFEH complaint, part of the DFEH's job is kind of as a threshold matter is to figure out, is this something that's in their purview? Is this something that is in their realm of things that they can enforce? And we'll get a little bit more into those details. But there's also also has a labor commissioner's office, which is also called the Department of the DLSE, and they have sometimes it's overlapping with what the DFEH can do, but sometimes it's their own labor laws that specifically have anti-discrimination and anti-retaliation claims. And these are largely going to be, labor code violations related to pay, but the Labor Commissioner's Office also has jurisdiction over some retaliation claims stemming from health and safety rules. So that would be, if it's a violation of a Cal OSHA regulation or a California Labor Code provision having to do with occupational health and safety, then that's going to fall under the Labor Commissioner's office. And they specifically have a retaliation complaint investigation unit that investigates these workplace retaliation complaints. And what we've been seeing a lot in California is retaliation complaints stemming from COVID. We've seen them in kind of a couple of contexts, either along the issue of pay, where it comes up as I was not provided my COVID paid sick leave, right? So that's a pay issue. Or it comes up as, for example, a complaint about COVID protocols. And so there may be a retaliation claim that stems from concerns over an employer's COVID protocols. So those are kind of the two universes in which I'll talk about this from the California perspective. And to give you some comparison points for statistics for complaints in California, the California's reports come out, they've been a little bit behind in issuing them. So the most recent one we have is the 2020 reports, which, as you can imagine, are going to be heavily influenced by COVID. But the DFEH had a total of over 4,000 cases that they actually investigated themselves. And they issued, so in California, in order for a plaintiff to file a lawsuit against their employer that's stemming from these anti-discrimination laws, they have a procedural requirement to go through the DFEH first. So they have to have an administrative charge, but the DFEH allows an individual to request an immediate right to sue letter so that it would not go through a DFEH investigation process, and that person could immediately go to court and file their lawsuit. So the DFEH issued over 13,000 immediate right to sue letters. And if you look in the breakdown of what was the basis for these various complaints, we see a huge number of them stemming from disability claims, sex claims, age claims, and then the other category that is far and above many of the other categories that they track is either a reported instance of discrimination or harassment or actively resisting discrimination or harassment. And then on the Labor Commissioner side, they had over 5,000 complaints filed in 2020. They accepted almost 2,000 of those for investigation. And you can see that a pretty good chunk of those had to do with COVID. And the top basis for the retaliation complaints with the Labor Commissioner were threatening to file a claim with the Labor Commissioner, which is protected activity. Like I mentioned, stemming from paid sick leave, or reporting a violation or non-compliance with a California or federal law, and then that other common category of complaints related to workplace safety. I think with that, we're going to pass it back to Lindsay to kind of go over the charges and burdens of proof that are involved in these cases.
Thanks, Megan. So first, before we jump into the burdens of proof and sort of the elements of these types of claims, we did want to just sort of go through logistically how this works. So with an EEOC claim, the charge must generally be filed within 180 days from the retaliatory act, but that time period is extended to 300 days if the state or locality has a law prohibiting discrimination on the same basis, which is going to be pretty much everywhere at this point. And so, if the state law exists, which it generally does, then the employee will have 300 days from the day the retaliatory act or the discriminatory act took place to file their claim or complaint with the EEOC. There's no specific time constraints on determination on a charge that's filed with the EEOC. And For those who have been through this process, it will probably have been your experience that it does take a long time for these charges to progress through the investigative process. But after 180 days, the individual who filed the complaint does have a right to file suit in court. And, you know, we often see that it'll sort of take until the employee gets like a no cause finding before they might take this next step. But technically, after 180 days of the EEOC investigating the complaint that was filed, the employee does have the option of filing a complaint in court and proceeding through that route instead of, you know, going through the full administrative process. When they do get a right to sue letter from the EEOC, an employee has 90 days from receiving that right to sue letter to actually file their complaint in court. And it's just important to sort of have these timelines in mind, because there are, though they've been rare in my experience, but there are the rare occasions where these timelines are not met, and that can be a pretty speedy way of, you know, getting the complaint to be dismissed, or, you know, if they didn't file within 90 days, pushing the court to dismiss the complaint. But so it's good to have these timelines in mind, though, like I said, it's usually the rare case that we see that the timing can be the ultimate deciding factor here.
Before I move on to the next slide, I'll give kind of the similar information for the California level. For the DFEH claims, for years and years, it's been a 1-year statute of limitations from the time of the discriminatory or harassing or retaliatory event. There was a one year to bring the claim with DFEH. That has now been extended to 3 years. And then once a right to sue letter is issued, there's a 1-year statute to bring a lawsuit. So there has definitely been a push on the California level to increase that statute of limitations quite significantly. And I don't know that we've really felt the impact of that changeover in the law yet. That was a pretty recent change. I also wanted to give a sense of what the DFEH, the kind of life of a DFEH complaint looks like, because unlike at the EEOC, not every claim that is filed or complaint that's filed with the DFEH is actually handled directly by the DFEH. So when somebody reaches out and files, they, like I said, they can request an immediate right to sue letter, and then they might take that letter and go ahead and directly file a lawsuit in court, and the DFEH would not be involved. But if it is submitted for investigation by the DFEH, then of course the initial question is whether this is something that the DFEH has jurisdiction over. If they don't, then they will still issue the right to sue letter so that the individual could file a lawsuit if they wanted to. If a complaint is actually filed with the DFEH, then it goes through the internal process, which involves investigation, usually highly encouraged mediation at some point, and it will work its way through the investigation process, with sometimes a case being closed and a right to sue letter being issued, sometimes settlement being reached, and sometimes in a very rare circumstance, the DFEH will actually decide to actively prosecute a case that has been filed with them in court. And those cases tend to be very high profile cases that tend to impact many workers and tend to involve systematic violations. And those, like I said, they do happen, but they're rare. There would be, you know, a couple of handfuls of those a year.
So this slide just sort of shows the basic standard that the EEOC, so this is at the federal level again, has to use to evaluate charges that are filed of discrimination or retaliation. So when investigating the charges, the EEOC assesses whether there is reasonable cause to believe this discrimination occurred. And this is going to be a lower bar than the individual would face, you know, if they took the complaint to court, you know, if they filed a complaint in the court system. it's going to be a lower bar, and it would be a lower bar than ultimately, the standard of proof that the complainant would need to reach to be successful even through the administrative process. But as at the investigation stage, the EEOC is assessing whether there's reasonable cause to believe the discrimination occurred. And they're going to make this assessment by reviewing the facts and the evidence that are provided by both the charging party and the employer during the course of the investigation. And it will give the charging party and the employer the opportunity to present that information themselves. And then also, as the investigation process progresses, the EEOC, may ask for interviews of individuals from the employer, but that's usually later on after the position statement has been submitted. And so that is an important part of this process. The employer is given the opportunity to provide a position statement that directly responds to the complaint that's been filed by the individual, and the EEOC thereafter, after reviewing the position statement, talking with the charging party, may decide to, like I said, do interviews. They could come on site, though we don't see that happen very often. And they could also request additional documents or information, which is something that we do see fairly regularly, that they may ask for some additional policy document or related information. So now going into sort of the specific elements that an individual needs to be able to prove to be successful in their complaint. And we're going to spend a little time on this because, again, this is important context for the position statement and how to develop the position statement, because these are the things that an employer is going to want to specifically address in a position statement to make sure that they are showing the case that they have for why the employee would not be able to prove one of these essential elements. And these elements are what we call the prima facie case. So this is the case that the individual who filed the complaint would need to be able to establish to even proceed forward in the process. And these elements will vary somewhat depending on the state or court jurisdiction that you're in. Different courts, might explain these elements differently, but it's really all sort of the same things that it comes down to. So first, we're going to go through the elements of a retaliation complaint. And that's going to be whether the individual engaged in protected activity. So whether the individual did something that is protected by the particular law in the context of Title VII. This might be someone who files a complaint with the EEOC. It could be someone who filed an internal complaint about, some allegedly harassing practice based on their race or religion or age. And so that would be considered a protected activity under the specific law. Then it would be whether the employer, the decision maker, had knowledge of that protected activity, if an adverse action was actually taken, and then whether there's a causal connection between the adverse action and the protected activity. So in the next couple slides, we want to give a little bit of detail on some of these elements because there is, a lot of case law out there. The various agencies, including the EEOC, have, their own sort of guidance documents on what this type of evidence looks like to meet each of these elements. So the first one is employer knowledge. And what this means is that the individual employee would have to be able to show that whoever made the decision to take the adverse employment action, whether that is termination, suspension, in the case of retaliation, it can be quite broad. So it could be, changing the person's position or responsibilities, whoever made that decision, whether they knew that the individual had engaged in protected activity. So going back to the example I gave of filing an internal complaint, if it was the employee's supervisor who made the decision to suspend them, based on some other conduct that might have occurred, did that supervisor know that the employee filed a complaint with HR about the supervisor or someone else at the company, that was harassing them or discriminating against them in some way? So they wouldn't have to be able to show that the decision maker actually knew of that protected activity, because otherwise, how could the protected activity actually factor into the decision? And as I alluded to in the prior slide, adverse action in the context of retaliation is also a little bit different. And in adverse action, we typically think of things like termination and suspension and demotion or failure to promote. Those are all sort of the typical, I think, adverse actions that we think of. But in the context of retaliation, adverse action can be a little bit broader than that. So the standard used for retaliation cases is whether the adverse action might have dissuaded a reasonable worker from making or supporting a charge of discrimination. So what this means is that, even if the adverse action doesn't necessarily cause a change in the terms or conditions of employment, whether it would dissuade the average employee from wanting to, file a complaint with HR going forward, or to feel like they could go to the EEOC if they had an issue going forward. And there are two main elements of evaluating whether the adverse action is actually an adverse action to meet this burden, and that is that it's materially adverse, and that it would be materially adverse to a reasonable employee or applicant. So it is an objective standard. And the EEOC will sort of evaluate the specific circumstances of the action to this individual employee, and then take a step back from that and say, okay, would a reasonable employee in a similar position not want to take this type of action going forward because of this resulting adverse employment action? And then finally, the last element that we'll sort of talk in some detail about is this causal connection piece. And I think the causal connection piece is really important because this is one that I think is going to be one that an employer would challenge related to any complaint of retaliation. I don't think I've ever had a complaint of retaliation with which I've assisted a client where we haven't push back on there not being a causal connection, or the employee's ability to be able to show a causal connection. So again, the employee has to be able to show a causal connection between the adverse employment action and the protected activity that they had engaged in. And at the EEOC federal level, the standard for a causal connection that has been developed by the Supreme Court is the employee must be able to show that but for the protected activity, the adverse employment action would not have occurred. So this is a pretty high bar, and it is a higher bar, for these Title VII cases that you'll see with other anti-discrimination laws. The burden could be different for state level anti-retaliation laws if they don't use the same language as Title VII. So this is like the highest standard, I think, of causal connection that an employer or that an employee would have to prove under Title VII to support a claim of retaliation, also discrimination, which we'll talk about in the next couple slides. So, and basically what it means is that the protected activity was a necessary antecedent of the adverse employment action. Again, though, at the agency level, so when the EEOC is investigating this, they're looking at reasonable cause. Is there reasonable cause to believe that the causal connection exists? So the burden at the investigation level, they still would ultimately have to be able to prove but for causation, but the EEOC might look at that a little bit more leniently than a court would look at it, or then the employee would ultimately have to prove later on to be successful on this particular element. And then the last specific thing that we wanted to address related to causal connection, because I think this comes up very often in cases of retaliation and developing these arguments to show that an employee can't actually, prove that a causal connection exists, is this proximity concept. So to be able to show a causal connection between an adverse employment action and protected activity, an employee generally needs to be able to show that they happen close in time to one another. that the employer took the adverse employment action shortly after the protected activity occurred. On the other side of that, if there has been an extended amount of time between the protected activity and the adverse employment action, then this is strong proof on the employer's part to be able to say, look, there's no causal connection here. And the Supreme Court has held specifically that a 3 to 4 month period between protected activity and adverse employment action is going to be insufficient to establish a causal link, that lapse in time sort of shows that the employer did not actually base its decision on the protected activity because the protected activity occurred so long ago. And where an employee is trying to support a causal connection solely based on proximity, that amount of time is going to be even more significant. It has to be very close. That's generally been the standard. And again, like I said, some courts and jurisdictions are going to differ on how they interpret this element. I know that some courts have found a shorter period of time, like 2 months is still too long to establish a causal connection. But again, that is going to be sort of when you get a specific complaint, evaluating, what state law you're in, or what state you're in, what laws are going to apply, and then the court that you're in and what they've held, and determining sort of what the actual standard is in that particular case. But proximity is really important, and it's going to be generally a pretty strong defense against the employee's ability to establish a causal connection. So now just briefly, the elements of discrimination. The first one, employee is in a protected category. Under Title VII, the protected categories are very general. It's just, race, religion, sex, national origin, and I think I'm missing one more, but it's just general protected categories. And when the employee files their complaint, they will sort of establish the basis for why they believe that they were discriminated based on race. And as part of that, they will say, what their race is and why they believe they were discriminated against based on that particular race. Same with religion. Under Title VII, the EEOC takes a pretty broad understanding of what constitutes a religion. And really what the employee is going to have to be able to show is that it's a sincerely held religious belief. It doesn't have to be any particular religion that they're pointing to. And it's just sort of establishing a belief in system that they have a sincerely held belief in that system. And like I said, that is rarely challenged. We have seen it challenged a little bit more in the context of COVID-19 and some of the, assertions that were made related to masking and vaccination around religion in that context. But generally, the EEOC takes a really broad view of that, and, sort of pushing back by the employer, at least as to the sincerely held nature of it, is going to be pretty limited. And then the employer takes an adverse employment action against an employee. That's similar to retaliation, but the standard is higher in the context of discrimination cases. The employee is meeting the legitimate expectations of the employer. And then finally, there's an inference of discrimination. So like I said, the adverse employment action in the context of a discrimination case is a little bit higher. The terminology is similar, a materially adverse change in the terms and conditions of employment, but that's sort of the important part there, is that it has to be a materially adverse change in the terms and conditions of employment. So generally, it's going to have to result in some discrete change in the terms of employment, such as hiring, firing, failure to promote, or reassignment, or another change that results in some substantial change in the employee's benefits or compensation or things like that. It is more disruptive than a mere inconvenience or an alteration of job responsibilities. So again, sort of a higher standard than what you see, or a higher burden than what you see in retaliation cases, where it is more, sort of this standard of would a reasonable person be dissuaded? Here it's, does it materially impact the terms and conditions of the individual's employment? And then the other one that I wanted to just sort of touch on briefly, or the other main element that I want to touch on briefly, is this concept of an inference of discrimination. This is one that is sort of stated differently in every court and might be phrased a little bit differently, but the concept here is that there's some evidence to show a connection between the person's protected category and the adverse action that was taken against them. And this is where the EEOC is going to look at, again, the knowledge that the individual decision maker might have had who implemented the adverse employment action about the employee's protected category, which in the case of religion, for instance, it might not be obvious. They might not know what the protected category is. So that actually could be a basis to assert that, well, they didn't know, that the employee held these religious beliefs, so they couldn't have discriminated against them on that basis. The EEOC will also look at statements, comments, or actions from those, within those employer representatives who the employee is asserting did discriminate against them. Or if they're trying to show sort of a general environment of harassment or discrimination based on their protected category, being able to point to comments or statements that would support that. And then the biggest way that we see this come into question is the similarly situated standard. So can the individual show that a similarly situated employee who is outside their protected category received better or different treatment than them? And that standard is fairly well defined. Similarly situated generally means that the comparator must have the same supervisor, be subject to the same standards, have engaged in the same or very similar conduct without there being any differentiating or mitigating circumstances that would explain a difference in treatment between the two individuals. And then before I kick it back over to Megan, we did also want to touch on the legitimate non-discriminatory reason piece of this evaluation. So, the way that that cases are generally evaluated, first, the individual employee has to be able to establish those elements that I just reviewed. And then the employer has the opportunity to show that the steps that it took, the adverse employment action that it took, was based on a legitimate and non-discriminatory reason. It could be that the employee was insubordinate, that they had issues with performance, were absent a bunch, that they violated some company policy or rule. And the burden here on the employer is really light. It's really just being able to present a legitimate reason for taking the adverse action. So if the employer can show, look, we had counseled this employee several times for either showing up late or not showing up to work and failing to call out. And so ultimately, we suspended them because of those issues. Then the employer can show a legitimate non-discriminatory reason for taking the adverse action. And it goes back to the employee to see if they can show that reason is actually pretextual, that the true reason is still discrimination, and this is why. All right, I will kick it back over to Megan to talk about some strategies for responding to administrative complaints.
Thanks, Lindsay. So with that context, we can start talking about kind of some general guidelines to keep in mind when an EEOC complaint or DFEH complaint letter comes across your desk, and there is the need to investigate, and as is the case for sure with EEOC, and is sometimes the case with the DFEH complaint, you may be in a position to be preparing a written position statement. So, the thing to do at the beginning, at the outset, is fully investigate the claim that the individual is asserting, but knowing that understanding that these retaliation claims are very, very high on the list of common claims brought, and that the burden is slightly different in the retaliation context. You want to take steps immediately if the complaining worker is still employed to ensure that there's no retaliation taken against that person. And sometimes if you think about work situation from the employee's standpoint, it is something going to be perceived by them as retaliatory action, even if from the employer's standpoint there's a legitimate explanation for that. It's still something that the employers want to keep in mind in taking any sort of action that could be perceived by the employee as retaliation for bringing the complaint. So, definitely think through any steps that might be taken against that employee, a change in position or a change in hours, a change in, desk location, or certainly bigger things like, disciplinary action, termination. Really think through those decisions when you have somebody who has brought a complaint forward. And then in terms of conducting the investigation, you want to, at the outset, collect as much information as you can, keeping in mind that if you're going to be committing something to a written statement, you want to have a really clear understanding of what happened and the universe of witnesses and documents and information that's available to you, so that you're, evaluating all of that before committing to a position in writing. So, collect all documents that might be related to the claim, interview any employees who might have knowledge, may have been privy to conversations, or may have been present during, any particular incident that is alleged in the complaint. And, make sure that you're documenting kind of that investigation and the findings, because the reality is, and Lindsay can speak to kind of timelines at the federal level, but the reality in California is that these things can drag on quite a bit of time. There might be quite a lag between the time somebody brings a complaint and when the employer finds out that there's been a complaint filed. And then there might be even more time that goes by during the investigation, and there might be even more time that goes by before a lawsuit is ultimately brought in court. And so you want to make sure that you're preserving the information that's gathered, so that if you need it down the line, there's it's clear what was done as part of the investigation, but it's also clear the underlying information that was gathered. And then ultimately, if you're preparing a written statement, that you're keeping that in mind, and that there's careful thought into what is being included in that statement. We'll talk a little bit more about kind of the impact that might have down the line, but you wouldn't want to, say, for example, take a position in the position statement, and then down the line in litigation take a contrary position, right? Because you have this position statement that lays out one version of the facts. So you want to kind of be able to preserve consistency, and really understand what really happened. In terms of the written position statement, the primary goal is the agency gets the kind of the version of the facts from the person bringing the complaint, right? So the position statement is the employer's opportunity to give the context from the employer's point of view. The employee may not necessarily be privy to all of the information that the employer can provide. So the employer can provide kind of the greater context of this employment relationship, the greater context on any particular incident that's raised in the complaint, and can explain the actions that the employer took in a way that, might be completely absent from the complaint, or may not be telling the whole story. So, in any sort of position statement, we like to, tell provide the information in a way that's really easy for the investigator to follow. To the extent it's helpful to rely on documentation to reference that, right? A clear reference to, say, a policy statement from the handbook or a clear email that establishes, a performance issue that predated the complaint. Things like that can clearly show, not only the sequence of events, but explain the employer's position. It's really an opportunity, as with any kind of communication, it's really the opportunity to establish yourself as a, trustworthy, as cooperative, as providing as much information as clearly as possible. Oftentimes the agency will ask for very specific information, but sometimes they just ask for a general, position statement. So there's an opportunity there to advocate for the employer's position and essentially persuade the agency why the complaint should be dismissed. It's also, important, especially if the request for information does not specifically ask for background, that you provide kind of that general background on the parties, right? So what type of business is the employer? What may be relevant context in terms of the work that the employee was doing? What role they were in, who they were working for, what kind of work they were performing, what they were expected to do. And then, certainly any applicable policies or procedures that applied to them, particularly if you're raising any performance issues. And then getting into the basis for the actual charge. You certainly want to, make sure that it's clear, that you're telling the clear story of the incident from the employer's perspective, in case that story is being told out of context from the employee's standpoint, the worker's standpoint, or there's just more information that can be provided. So, who all was involved, who are the key witnesses, if there were issues with employee performance, that's something that's, of course, important to discuss. Any explanation for any actions that the employer may have taken against the employer, to explain and show why any action taken by the employer was lawful and was not discriminatory or harassing or retaliatory. The position statement, in addition to just providing the facts, is naturally going to take a position in terms of legal analysis. So there's going to be a section where you're applying the facts to these elements that Lindsay was discussing a few minutes ago. And the key there is to make it clear that there was, legitimate reasons for any adverse action taken, that there, is a lack of causal connection between any protected activity that the worker took and any adverse action that may have been imposed, or that the employee's activity was not protected at all, or doesn't rise to the level of, discriminatory activity or harassment or retaliation. So walking through that analysis is important. And this is where, working with counsel can be very helpful, because sometimes the legal framework is really dependent on, what kind of claim is being asserted. And so that's something you want to take great care in doing. And also, like I alluded to earlier, making sure that anything that you're including in the position statement is not, that there's not a risk of that being inconsistent with a information that might be provided down the line, or a legal position that might want to be taken at a later date, to make sure that you're not setting up a situation where this position statement is inconsistent with a position you might need to take in a different context, in a litigation matter, for example. The supporting documentation is is also something to give a lot of thought to, because certainly if something specific is requested, it's important to be cooperative and comply with the request. But in terms of providing documentation above and beyond what's being asked, taking careful consideration of what documentation to provide, with the thought in the back of your mind that this information it is going to be provided to the opposing party, or could be requested as part of, in California matters, could be requested as part of a public records request, or as part of discovery in a litigation matter down the line. And then particular for the EEOC, the position statement and any non-confidential attachments are released to the charging party. And then the charging party has time to respond, and that response is not provided to the employer. So, sometimes with these agency procedures, although the agencies, are operating based on, statutory and regulatory rules, sometimes there's not as kind of what the process looks like is not necessarily as transparent sometimes as say a litigation matter where everything is generally shared with both sides in the process of discovery. So it's just something to keep in mind that you may not be at the agency level, you may not have 100% understanding of what the charging party's position is at various points in time. And then it's great to have clear guidelines and kind of things to keep in mind in preparing the position statement. Once a complaint comes across your desk, but it's always good to keep in mind, ways to avoid the complaints in the first place. So Lindsay's going to finish us off with that discussion.
So I know we only have a few minutes left here, so we'll go through these rather quickly. But we wanted to sort of touch on, I think there's sort of three major ways that we see as, the best things you can do to either try to avoid complaints in the first place, or to, if a complaint occurs, to ensure that it's made internally and that the employer sort of has a handle on the investigation and the response, as opposed to the complaint going outside the employer's process to one of these agencies. So the first is to have a clear complaint policy. And this is really important, not only from the perspective of facilitating employee complaints and making sure employees know and understand how to file complaints with generally HR for the employer, but also in the context of a harassment complaint, for instance. One of the affirmative defenses that an employer can rely on in responding to that type of complaint is that they have a complaint process in place, that they have a way for employees to bring these things to their attention and for them to address it. And the complaint policy and process is important there. So just some suggestions for how to have a complaint policy and how to make that complaint policy available. It should be in writing and disseminated to employees so that they know the process, they understand how it works. The complaint policy should make clear what the different avenues are for filing complaints to make sure employees know they don't have to go to their supervisor, particularly if the supervisor is the one that might be that they're alleging is discriminating or retaliating against them, but there's other resources. And lets the employees know that if they do file a complaint, what the process will be, and that it will be prompt and ensure that there is an investigation and some response. So in addition to having a policy, it's also really important to train employees. And this is important from, potentially a preventative perspective, as well as, again, sort of facilitating internal complaints. So you want to make sure that employees are trained on what constitutes discrimination or harassment and retaliation, how to avoid that type of conduct, how to recognize and address that type of conduct. And then again, this training should include the actual complaint procedure and process. Another really important aspect of training is management training. This is so important because managers are usually the front line for employee complaints, and they're also the people working with employees on a day-to-day basis. So the ones that are generally accused of, potentially discriminating or retaliatory behavior. So making sure that management has specific training on how to respond to complaints, what their role is in the complaint process, the types of actions that could be considered adverse from both a discriminatory or retaliatory perspective. And then also, effectively communicating if an adverse action is taken, why it's taken, and that reason is legitimate and has nothing to do with protected activity or protected category. And then the last piece of this, and I think Megan covered this well, it is, when you're doing the investigation, when a complaint, does come forward and you may or made aware of it, is this documentation piece is so important. And so that's sort of the last slide here is the documentation. And it's developing and maintaining the documentation that will be important, from the perspective of showing that if an employee did bring a complaint internally, that it was thoroughly investigated, documentation of the employee's performance issues or absences. If those ultimately serve as the basis for an adverse employment action, it's important to have that documentation in place to show that the employee was made aware of these issues prior to any alleged protected activity, for instance. And that, this documentation supports that the employer made this decision without any consideration of protected category or protected activity. And then related to investigations, again, an important part of having a complaint policy and having this investigation process is also, demonstrating if this does ever go to the EEOC, what the employer did, but also to show employees that, this is the process and this is what the employer will do to ensure that your complaints are addressed sufficiently internally. So just keeping notes throughout the investigation process of interviews, recording the reasons that you develop an understanding of were the basis for the adverse employment action. And then ultimately, it is important in some way, shape, or form, even if it's just on a general basis, to let the complainant know what the findings and ultimate resolution were, just so that they do know that the employer investigated, the employer came to the conclusion, and their concerns were addressed. So with that, that is the conclusion of our presentation. We do have one more webinar this year that we encourage everyone to check out. And then we also have available on the next slide are our blogs that also address a lot of these issues. We've written about a lot of different employment related issues, whether it's this specifically or, different things that come up for you all. It's a really good resource for our suggestions and guidance related to some of the major employment issues out there, as well as OSHA and Cal-OSHA and MSHA. And then finally, I think this presentation is available for continuing education credits. So if that is something you are seeking, then the contact information for Teresa Green is provided below, and you can reach out for her for information on that. And finally, here is our contact information. We immerse ourselves in these issues on a day-to-day basis, so we're happy to talk about anything further. If you have specific questions, feel free to reach out.